My name's Alex Haile. I'm a domestic attorney in our Winston-Salem office. Emergency custody is when one party would approach the judge and say that there is a substantial risk to the minor child. There's really three things that the courts are looking at to determine whether or not emergency custody is justified. One would be if there's a risk of substantial injury to the child. The second would be if there's a substantial risk of sexual abuse or emotional harm to the child. And three would be if one parent is threatening or potentially about to leave the state to evade the jurisdiction of North Carolina. If one of those three situations is present, it's important for that party to obtain an attorney to file a motion for emergency custody. When that motion is filed, the attorney or the party would approach the judge ex parte again, so without the other party present, and say, "Judge, here's the situation. We believe that one of those three circumstances is about to happen, and we would request that you grant emergency custody." When emergency custody is granted, the party that the emergency custody is granted to is granted sole primary and legal custody on a temporary basis of the child. They would be able to go get that child from school immediately, and the child would be in their complete care until there's a return hearing. The return hearing is similar to how it works in domestic violence protective orders, where you're coming back for that 10-day return hearing. So in about 10 days, you will have a time to present your evidence, and it allows the other party to present their evidence as to why there isn't an emergency. So the third thing that the courts are looking at to determine whether or not there is an emergency is if one parent is taking the child out of the state for the purposes of evading the jurisdiction. This doesn't consider when one parent is simply going to a different state for a week on vacation or something like that. This is looking at where a parent is potentially moving to another state and saying to the other party that, this is it. You're not going to be able to see your child anymore, kind of too bad, so sad. So say that you're the party who has wanted to move to the other state. You've made it clear to the other party that you want to move to that other state. You've let them know that this is going to happen. When you do have that 10-day return hearing, that's your turn to put on evidence that the other party knew that this was happening, and also to argue to the court that you're not trying to evade the jurisdiction, and in fact, you've showed up to the hearing, you're here today, and it's your turn to put on the evidence after you've determined that there isn't an emergency as to maybe why the child does need to go to that other state with you. Say you've been the primary caregiver or something like that. It's not necessarily a slam dunk where you're absolutely going to be able to go to that new state or to that new residence. However, it is your time to put on evidence to show the judge why there isn't an emergency or why you aren't evading the jurisdiction. So if you are a party who has lost your child due to an emergency custody order, it's very crucial that you consult with an attorney as quickly as possible, as soon as you're served. You would really want your attorney to be prepared for that 10-day hearing. There really isn't anything that the attorney can do between the day that you're served and when the 10-day hearing occurs. You want to give your attorney as much time as possible to gather evidence so they are prepared for that 10-day hearing and they don't have to request a continuance or something like that. It's also important to have an attorney in that type of situation, because if there isn't an emergency, you need to be sure that you have an attorney that's there so they can enter evidence to the court to show why there isn't an emergency. If there's text messages, if there's photos or something like that. We have very strict evidentiary rules that allow us to determine what is admissible and what is not admissible. If you represent yourself in an emergency custody case, you're going to be held to the same standard as an attorney, and you may not know the correct specifications or when to object when the opposing party says something. So it's very, very important, if you want this emergency order to go away, to make sure you consult with an attorney and hopefully hire an attorney as quickly as possible so you can get your emergency custody taken care of quickly.